We need to talk about the rule of law. A podcast by Verfassungsblog and Deutscher Anwaltsverein. We need to talk about attorneys. You need them at your side when the government decides to go after you, and this is what makes them a target for authoritarian repression themselves. In Turkey, defending opponents of the government in court is a high-risk occupation, as the large number of incarcerated lawyers testifies, and we have to talk about that. On the other hand, lawyers appear to be at the core of some of the worst scandals which are corroding the rule of law right now, most prominently the Cum-Ex scandal, a tax evasion or maybe even downright fraud scheme of staggering dimensions in Germany. So we will have to talk about that too, I guess. We have 4 distinguished guests this week in our 6th episode of the Rule of Law podcast we are doing together with, speaking of lawyers, the German Bar Association DAV. Margarete von Galen is a criminal defense lawyer and a member of the State Constitutional Court of Berlin and the vice president of the European Lawyers Association CCBE. And then there's Mikołaj Pieczak, an advocate from Warsaw, former chairman of the Human Rights Committee of the National Bar Council of Poland, and now the chairman of the Warsaw Bar Council. I will also talk to Jeremy McBride, an attorney from Strasbourg and one of Europe's most experienced human rights litigators. And I will talk to Coşkun Yorulmaz, a Turkish lawyer currently in exile in London. My name is Max Steinmeiß. I'm the editor of Verfassungsblog. Hello, everyone, and a very warm welcome to all of you.
Hello.
Hello, good morning.
Hello.
First, let's talk about the country with maybe the most alarming state of affairs with respect to advocates in Europe, which is Turkey. Mr. Yorulmaz, what is the situation on the ground there?
Well, I would describe it as terrible, really. In one word, but the problem which affects lawyers is manifolds in Turkey. I mean, there are problems, human rights issues, which affect everybody in Turkey, including the lawyers, and there are problems that affect the lawyers who are trying to do their duty on the ground, and of course there are problems of the legal profession as a whole in Turkey. And in my opinion, the biggest problem which affects lawyers is the anti-terror laws in Turkey, and they're very broad and very vague, which means any lawyer could end up in jail on trumped-up charges or on very flimsy evidence.
And they do in large numbers, don't they?
Yes, I mean, thousands of lawyers have so far been prosecuted in Turkey for terrorism-related charges, and many of our fellow lawyers they are behind bars as we speak. So, and the other issue is the situation of the Turkish judiciary. Thousands of judges and public prosecutors have been dismissed in the wake of the coup attempt back in 2016, and these judges and public prosecutors they're still behind bars, and some of them in solitary confinement, and which meant the very fabric of the Turkish judiciary has changed completely. Now, judges with less than 2 or 3 years of experience make up the 45% of the Turkish judiciary, which you can say they've been appointed after these judges and public prosecutors have been dismissed, and you can argue that they are pro-government because now the Turkish government has a great say on the High Board of or Supreme Board of Judges and Public Prosecutors, and they decide who becomes a judge and public prosecutor. So the new judges and public prosecutors are inevitably pro-Turkish government.
I see. So is it still possible at all if you find yourself in at the wrong end of a conflict with the government in Turkey to get independent and viable legal defense counsel?
Well, the thing is, first of all, if you're a suspect of terrorism-related charges, you will find it very difficult to find a lawyer who would be willing to represent you, because one of the biggest issues is lawyers. They get, they get associated with clients, and they can find themselves in hot water. So this is what happens. I mean, we've seen some indictments where the only evidence against a fellow lawyer was his client list, really, and there is the issue of legal aid. So basically, when you when you find yourself in a police station, they decide basically who's going to represent you as a lawyer, and most of the time they appoint junior lawyers as your counsel, and these junior lawyers, they're always almost always very intimidated to act in your best interests.
Mm-hmm. And is this a kind of a double state phenomenon, in the sense of there's on the one side the political issues which have this sort of problems, but on the other hand there's the ordinary daily life criminal law situation where it's still different, or is this actually corroding the entire system already?
Well, the thing is, I mean, they are very, very interrelated. I mean, the issue is, as I told before, it's manifold, and there is the political element to it. The government targeting the whole legal profession as a whole, in the form of the new law for lawyers bill,
Mm-hmm.
which made certain very active bar associations lose their strength in defending or in their fight against torture and ill treatment in prisons and police stations. But then again, this is a lot on a general scale. But as you said, there is the problems that fellow lawyers have to endure on a daily basis when they're always in risk of their communication with their clients being intercepted. And as we've seen in the recent mass arrest of 46 junior lawyers in Ankara, and all the evidence which was presented to them at the police station when they were being interrogated was their telephone conversations with their clients. I mean, this is another issue, and of course they can't do their jobs properly because for some criminal procedural matter, most of the criminal investigations are done in secrecy. So there's a secrecy order for most of the terrorism-related offences. And when I say terrorism-related offences, I mean, I told you the Turkish anti-terror laws are very broad. Up to date, more than 400,000 people have been prosecuted for terrorism-related offences, and some 220,000 of them have been convicted. I mean, can you imagine convicting more than 200,000 people as terrorists?
Mm-hmm.
So, yes, I mean, it is not easy, both from a political aspect or on a daily basis.
Yeah, I suppose it's not. Mr. Pieczak, the Polish government has also been has also had a lot of bad press in recent years with respect to the rule of law. What about the legal profession? Is it under duress as well in any sense of the word? Is client-attorney privilege still intact in Poland?
Well, as you know, over the past 4 or 5 years, we've observed an attack on the independence of the judiciary, the rule of law, the division of powers, and there has been a lot of focus on access to an independent court as a mechanism guaranteeing the respect for rights and freedoms. But I think society as a whole, and in fact, all of Europe has perhaps overlooked, and this is also, I think, overlooked in much of the jurisprudence of the European Court of Human Rights, has overlooked the essential role that lawyers play, independent lawyers, lawyers who are protected in terms of client-lawyer confidentiality. It's all fine and good to have an independent court, but if you remove the advocates or you allow for violation of their privileged communication with their clients, that access to an independent court becomes, in effect, an illusion. And so we have not been targeted to the degree in Poland that the courts have. But you can see the courts now face more than a chilling effect. They face disciplinary repressions using mechanisms, legal mechanisms, which we protested against as anti-constitutional. And now we've seen over the past year an increase also in targeting lawyers. Recently, we saw Roman Giertych, a very prominent lawyer who is famous for taking cases against the government, which I dare say is the role of any decent advocate. It's always to stand on the side of the weaker individual, the weaker company, sometimes against the powers of the state. That's our very role. So Mr. Giertych was famous for taking these cases, and the cases that he ran were considered very unfriendly to the government. And recently, he was arrested on the steps of the court, leaving the courthouse. They didn't do it in another place. It was manifest. It was supposed to be a show, to show that lawyers can be arrested as well. Then his office and his home were searched. We barged in as the bar counsel to make sure that the client lawyer privilege is secured, but many of the documents covered by client lawyer privilege were seized by the special anti-corruption police.
Oh, wow.
And most notably, there was an abuse of an instrument on the part of the prosecutor who, by way of a unilateral decision, suspended an advocate, his procedural opponent, in his rights to act as an advocate. So you're seeing a situation where a prosecutor is removing a politically unwelcome advocate by way of a unilateral decision from the possibility of conducting his work as a lawyer. So we've seen more and more of these kinds of repressions. I myself have faced an attempt to initiate disciplinary proceedings against me when I was defending one of the judges who protests against the unconstitutional changes to the judiciary. And to my astonishment, on one of the disciplinary trial hearings, the ministerially appointed the disciplinary prosecutor in Poland, so this is somebody who's very much subject to political authority, demanded that I be subject to disciplinary measures for filing motions before a court. Now that just goes to show you that they're very focused on creating a chilling effect among lawyers, because if they can successfully repress a prominent lawyer like Roman Giertych, if they can boldly file unjustified claims against me, it's sending a signal to lawyers throughout Poland that you shouldn't defend the wrong people. Be careful which cases you take. So by attacking the lawyers, it's not the lawyers that are actually being targeted. It's the entire system of procedural safety of rights and freedoms, in which lawyers play an absolutely essential role. That's why we're fighting so hard not only to protect judicial independence in Poland as the Bar Association, as civil society, but we're also trying to raise awareness that the independence of lawyers, client-lawyer privilege, are on par with judicial independence in terms of their place in this system of safeguards, of mechanisms guaranteeing rights and freedoms.
Okay, so Poland may not have been gone as far as Turkey in that respect, but is going down the same road.
Well, when I hear our colleagues from Western Europe congratulating Polish lawyers on their courage, I always feel it's an inadequate and grossly overused term in that context. When I think of our brave colleagues from Turkey, from Belarus,
Yes.
and from many other countries where the independence of the bar has pretty much been overturned, and as a result, lawyers are bereft of any safeguards in their conducting of their professional duties. And the lawyers themselves are targeted in a much more brutal, much more direct fashion. So my hat's off to especially all the lawyers who are now repressed and met with obstructions in Turkey and in Belarus.
Speaking of Western Europe, Mr. McBride, in the UK, the government is also on the record polemicizing against quote unquote lefty lawyers who allegedly push some sinister agenda by promoting their clients' interests in court. What is going on there? Is there a common trend to vilify defense attorneys and trial lawyers in these days in Europe in general?
Possibly, yes. If you had asked me to take part in this a few weeks ago, I would have said there was no problem in the UK at all. I mean, if you look at the situation of lawyers in general over the last 2 decades, you have very few instances of where lawyers are put under pressure of any kind. I mean, the problem for lawyers is much more the question of funding for public services. But that debate has certainly changed, in part, similarly in the way we heard about Poland, because particularly as the period of Brexit has undergone, where there have been a lot of challenges to the various moves that have been taken in support of that, you first had very serious attacks upon the judiciary. I mean, portrayed in the press as being traitors and so on, and really a failure by the minister who is responsible for the justice system to actually stand up and defend the judiciary. So that trend is similar to what happened in Poland, but of course it's nowhere near the same. But as far as lawyers are concerned, that there hasn't been great pressure until this recent outburst, which has been fairly coordinated with both the interior minister and the prime minister speaking, as you said, about lefty lawyers. And what their complaint is, or their allegation is, that lawyers are acting improperly because they are taking cases for people who are migrants, who are resisting expulsion decisions, and various issues relating to that. And that attack is not simply an attack, because it has also been followed by a physical attack by an individual who clearly was prompted by this kind of discussion to go with a knife to a lawyer's office. Fortunately, no one was actually injured, but it clearly was a threatening situation. And so you see this kind of atmosphere being generated, and there's been no attempt to row back from the statement by the Prime Minister or the Interior Minister. Indeed, the Interior Minister was warned by the intelligence services that this was not a good idea, because there's quite clearly a serious situation in terms of right-wing terrorism, not just simply so-called Islamic terrorism, but right-wing terrorism. And what they were concerned was the possibility that this will be incited by the statements of this kind. But the Interior Minister has continued to make those assertions. So the situation is very strong. What is good has been a strong sense of solidarity on the part of lawyers. A very large group of lawyers wrote only recently to the Prime Minister demanding an apology. There have been strong speeches by former judges asserting the need to protect lawyers. So at the moment, the atmosphere is one of great solidarity, but you can see there is a danger if you continue down this route.
Okay. Let's move to Germany for a minute, Mrs. von Galen. I mean, of course, it's important to keep things apart and not to compare egregious cases with rather minor issues, but still, there have been concerns raised lately about the regulation which obliges lawyers to notify the authorities in the event of any suspicion of money laundering at the hand of a client. So is this a reason to suspect that attorney-client privilege is in danger in Germany too, in some ways?
Well, as you rightly said, it's difficult to raise a German voice when you hear from Turkey and from Poland and also from other countries like Bulgaria, where individual lawyers are threatened by the public authorities, etc. But I think I have the right to raise my voice, because I think a country like Germany maybe should at least take the part providing or exercising best practice with regard to the legal, to lawyer's client privilege, with regard to the respect of the rule of law and the special role the legal profession should play in this regard. And there also, I think we can observe that Germany is, going in a direction where I would say this is not really best practice. We have actually a rest of anti-terror law, which is that if you defend a client who is suspected of being member of a terrorist organization, the written correspondence between the client and the legal defense and the defense counsel is not protected. It has to be controlled by the court. So there is still some relict from former times when we had the difficulties with the situation with the in the early 70s with some inner German people who thought to use violence against authorities. But now we also have a draft law, which it basically is has the issue of investigations against companies. And in this law, it is foreseen that all lawyers' clients' correspondence, everything which is written, may be seized or confiscated when it comes to a criminal proceeding against a company or against someone. So if this written correspondence is not part of a criminal defense mandate, everything can be seized. So and there's obviously no the Ministry of Justice who drafted this law. They only think this is correct. It's a good source. This correspondence between the lawyers and their clients, and it should be confiscated when it's needed to investigate a case against a company economic in the area of economic crime. So this is really, there are some developments where I see that there's not this is not best practice, and it's not it does not mirror the respect for the legal profession as it should be with regard to the rule of law. And if I may just say a word regarding Europe and the European Commission. I really would like to point out that it was a shock. I cannot say it differently. It was a shock for the legal profession to see that the Commission issues a rule of law report, which it was presented to the press. It was an event, and etc. And the legal profession is not mentioned at all. And so when I read this report, I was just thinking whether the legal profession might just disappear. I mean, the independent legal profession begins 250 years ago, roundabout. So maybe we are in a historical situation where the public authorities at least think that the rule of law can be exercised and can be lived without independent bars and without independent lawyers. So I think I don't know what the Commission really wants to say with this omission of the legal profession, and I don't know if they really are aware how dangerous this is. But I think with regard to countries like Turkey, like Poland, from what we heard right now, it's really dangerous to issue such a rule of law report and giving the impression to the European community that the independent bars, independent lawyers are not an issue when it comes to the rule of law. So I think this is really alarming.
I would like to return to the European reaction and the ways of protecting the rule of law and the legal profession in particular in a minute. But before, I just to complete the picture, as I mentioned before, on the other hand, have also been scandals lately, which did also tremendous damage to the public trust in the rule of law. The Cum-Ex scandal in Germany, a scheme which apparently has been concocted principally by a bunch of Frankfurt lawyers who are now criminally investigated. A colossal tax manipulation scheme. Are some lawyers, in fact, rather part of the problem than the solution when it comes to the rule of law too? Maybe this is something we need to talk about as well.
Yeah, well, it's always difficult to blame the colleagues, but I only can say yes. It is a problem. I must say I'm very, as being a criminal defense lawyer and also having to do with the Cum-Ex cases, I really must say it's a problem that some lawyers really bring harm to other people, because as you said, there are some lawyers who are prosecuted now, but there are much more individuals and banks who are prosecuted, and this all would not have happened if the legal advice some years ago would have been differently. And I really think this is a problem, and I'm not sympathizing with these colleagues at all.
Okay, Mr. Pieczak.
Yes, thank you. I think that the flip side of having an autonomous bar association, which, as I said before, the independence of the bar serves the independence of individual lawyers, and the independence of individual lawyers is absolutely necessary for the protection of rights and freedoms. So the independent bar serves the protection of rights and freedoms, ultimately. And now, saying that, there's a flip side. We, of course, as a bar association everywhere throughout the world, our main duty is to protect lawyers against repressions. But on the other hand, that's connected with a very high standard we must hold our lawyers to, and we must ensure that our independent disciplinary proceedings, if we don't wish to forfeit them, must hold lawyers accountable at a very high standard. And that is a natural problem that I think all bars throughout the world deal with. We have still an independent disciplinary court system in the Polish bar, but there have been over the years many attempts by various governments to inhibit that independence. And I think if we want to be legitimate in advocating that this independence of the disciplinary courts remain strong, remain robust, we need to ensure that these courts deal promptly and very effectively with lawyers who do abuse their profession and who do violate clients' trust and violate the public trust in our profession. Because ultimately, that hurts the citizens, it hurts those who should benefit from the protection of their rights and freedoms. As I can tell you that as the Dean of the Warsaw Bar, I have on multiple occasions had the very doubtful pleasure of signing decisions to execute the judgments of a disciplinary court, removing our dishonest colleagues from the Bar Association. I always do so with a heavy heart, but with absolute confidence that it's the right thing to do.
Right. Let's return to the European system of protecting lawyers from authoritarian crackdowns. If there's one thing that we've learned over the last years, is that the rule of law in its entirety is a very much a European issue, and that this is not only within the European Union but also within the framework of the European Convention of Human Rights, which includes Turkey. Mr. Yorulmaz, Turkey being a member state of the European Convention of Human Rights, and there have been a number of convictions before the Strasbourg Court. What about the protection of lawyers under international law? Is that sufficiently strong? And if not, what could be done about it, or should be done about it?
Well, personally, I'm not really happy with the European Court of Human Rights, because I mean, for the purposes of not opening up the floodgates they have gave their authority back to a Turkish judicial body, so to speak, which made it impossible for anybody to bring their cases before the European Court of Human Rights for many, many years. And this is in the words of some people from the Venice Commission. It delayed people from reaching justice for at least 15 years. And the latest visit of the president of the court to Turkey to meet with the President Erdogan and visiting the mayor of a southern city who replaced an elected mayor was awful. When I say that, for example, some lawyers, they're public lawyers, they work for the government or public bodies, and these people have been dismissed from profession by emergency law degrees, and they couldn't bring their cases before the European Court of Human Rights, just because the European Court of Human Rights thought this commission in Turkey, emergency commission, was an efficient remedy, domestic remedy. And in that way, I feel most of the victims of the persecution in Turkey, they feel let down by European institutions, really. But having said that, for example, in EU, the latest report makes mention of lawyers in Turkey, and the Commissioner of Human Rights have been very, very supportive of the Turkish lawyers. So I can't thank them enough personally, really. But an institution, I think, not only Turkish lawyers, but in general, the people who've been targeted by the Turkish government feel really let down.
Right. There has been a lot of discussion over the last years about the necessity of a European convention for the lawyer profession. Ms. van Galen, what is that about, and what should this convention contain, and what is the state of this debate?
Well, we thought as CCBE that a convention, drafted by the Council of Europe, would be a very good thing to ensure the independence of the legal profession in all countries of the who are members of the Council of Europe, and not only in the European Union but beyond. And so we initiated this, and fortunately we met open doors. And now it is in the stage that the Council of Europe has commissioned a feasibility study, which is obviously already finalized, but we don't know, we haven't yet seen it. But so it's going on, and I think in the beginning of next year there will be the next step of a decision based on this feasibility study whether to draft a convention or not. But of course we hope that this goes into the direction of drafting a convention. And I think it's important to have some basic principles like independence, legal privilege, and all these issues we're just speaking about, because also in Europe, in the European Union, it's very different. For instance, Austria has included the legal profession in their constitution. In Germany it is not. So in other countries it might be again different. So I think it is a very important and would be a very important step to have a convention which applies for all the European states, where certain principles which are necessary to have and to live if you want to uphold the rule of law are fixed in a convention which then will be binding for all the countries.
I see. Mr. McBride.
Okay. Well, I'm the author of the study.
Nice to meet you.
So I'm going to say it is going to be discussed next week in the committee, which is responsible for making the decision, the report to the committee of ministers. I don't know what the outcome will be, so I can't say that. But can I go back a few steps to talk about the European convention system, because it's important to understand how effective it is. What was said about the problem with Turkey is absolutely right, in the sense that if you can't get past the effective remedies barrier, then it's not much use. Much of the provisions of the convention are quite helpful for lawyers. I mean, if you talk about problems of physical attacks, it's very clear the convention protects you. It protects, to a certain extent, interference with work. But as we've heard already, there are problems with the question of client confidentiality, and some people would say the case law of the court is not sufficiently strong in that area. But one of the other problems is that some of the things which affect lawyers are not protectable by lawyers because they are the rights of the client, and the client may not have the interest in pursuing them. So, for example, in terms of access to documents, that's a right of the client, not a right of the lawyer. So there are areas where improvement is needed there. There are big problems in terms of discipline, admission to the profession. The case law has much improved in recent years because there have been some very serious abuses by some countries in terms of that process. But the area which is weakest in the convention is the question of institutional guarantees, in other words, for the bar associations themselves. And this came out very strongly in relation to the recent changes which we heard about earlier in Turkey, because when the Venice Commission was looking at the question of what standards were applicable to the change in the attorney law, it was very limited in terms of legal obligations to protect the independence. And there's also a lot of uncertainty about what that really means. So that's part of the background. The question of going forward, clearly a convention could add some value. There's going to be a lot of debate about this, so it's not a clear-cut issue. But if you have a convention, it must be more than simply what you currently have, which is the recommendation, which is a statement of principles. They're all good principles, although some could be clearer than they are. But you need something to make sure the convention is implemented. And that's a much harder thing in terms of getting states to agree to, because the European convention system, even with the difficulties we've heard about Turkey, is slow. I mean, most cases you're talking about 5 years. And even in the recent tragic case of the Turkish lawyer who died while on hunger strike, the court there wasn't even prepared to issue interim measures. So you have a real difficulty in terms of dealing with the problem when it really exists. So in discussions about a convention, you need to focus not only in terms of the principles in it, but actually how you're going to realize those principles.
Right. Okay, we're getting close to the end of our time. To conclude, I would ask you, all of you, a question which I'd ask you to answer very briefly, which is if you imagine for a minute that you were the defense lawyer of the main suspect of a big terror event in your country. How safe would you feel not to become a target of the security authorities yourself? Maybe let's start with you, Mr. Pieczak.
Well, I'm in the comfortable position that it's not a hypothetical scenario for me. What I can say is that the main criticism one faces, the main form of repression, is the attacks via the public opinion by the government-influenced media. There is a black PR campaign against lawyers who take terrorism cases, espionage cases, or other cases which are conducive to populist criticism of the legal profession. regrettably, the downside is that we have a very strong suspicion. We have reasons as a profession, and in particular, the lawyers like myself, like other lawyers who are dealing with politically sensitive, unpopular cases, we have reason to believe that we are subject to wiretapping and to unmonitored surveillance because there's a lack of adequate civil control mechanisms over the counterintelligence, intelligence, and policing agencies. We've in fact filed an application to the European Court of Human Rights, along with several colleagues from non-governmental organizations, just arguing that we have no effective means of even finding out whether we as lawyers are being wiretapped in violation of client-lawyer privilege, and as a result, no effective means of verification of the legality of this wiretapping. Until there is robust and credible civil control over policing, intelligence, and counterintelligence agencies, lawyers will always be a prime target for surveillance, including illegal surveillance, just because we have access to very, very sensitive information, in particular regarding terrorism, espionage cases, or cases which are politically sensitive for other reasons.
Right. Mr. McBride?
If it comes to the question of prosecution at the moment, I wouldn't be concerned. I think we have still a strong independent judiciary. But the kind of problem I was talking about where there is public pressure, which we've heard about Poland, that can easily disappear. So the question is, it's not necessarily a long-term confidence, but at the moment, I would still be confident.
Right. Mrs. van Gaalen?
Yes, I think I would also be more or less confident that I will not be a target, in at least in the media, etc. It would be at least very unusual in Germany. However, I also would say I would be careful what to speak on the phone. I would be there would be some caution. I would have to be a little bit cautious how I deal with the clients. Not because I'm doing anything wrong, but I would not be totally sure that everything on the part of the state which is done legally, but I would not fear to become a target myself officially, and for everybody to know, etc.
Okay, Mr. Joelmas?
Well, it's not a hypothetical question for me. I'll leave it at that. But as a Turkish lawyer, prosecution wouldn't be the worst of my worries, really. I mean, my worry would be whether I would be tortured or ill-treated in a police station or in prison, and whether I would have to give my life, just like my colleague Ebru Tintik did, in quest for justice, or would I be, threatened by sexual abuse, like one of my young fellow Turkish lawyers, Erdem Yildiz, has been, just because he was representing a person which the Turkish government wasn't happy with. My worry would be, would I lose my life when I was trying to flee Turkey through the Greek border on a dinghy boat with my family? And my worry would be whether I would have my assets confiscated, like many of my colleagues have seen, and whether I would have to drive Uber after 20 years of legal profession. So these would be my worries, really. And for Turkish lawyers, this is a daily thing. We are worried, and we lose friends, we lose clients, even we lose family. When you're victimized and vilified, this is what happens to you. You start to lose people around you, and that is a big worry. And yes, like the other Turkish lawyers, I'm worried as well.
Yes. This is what is happening. This is the reality. We in Europe. This is not just neither some hypothetical scenario nor something which is taking place in some remote country. This is Europe. This is the state of affairs of the rule of law in Europe. So I'm very glad we've talked about this, even if this episode ends on such a grim note, which I find completely appropriate in this context. I thank you very much, all of you, and I wish you all the courage and all the strength and all the luck you will need in your profession. And again, thanks so much for sharing your thoughts and experiences with us. And good day to you.
Thank you.
Thank you. Bye-bye.
Okay.